It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and cures the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded to the ordinary courts. In recognition of the special nature of the military, legislation must be put in place that establishes and confers on the courts martial and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldier's right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009, Uganda Law Society against Karugaba, that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address in order as follows. In order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the Executive and Parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope to look into. A. Administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offences falling under their jurisdiction. B. Limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offences with no power of imposing sentences or imprisonment. C. Utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offences committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offences attracting life imprisonment and below. Or D. With the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They will exercise jurisdiction over offences triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E. Amend the Constitution to establish superior courts within the military court system under Article 129 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to strike specific military offences of a capital nature and all other capital offences under existing laws committed by military personnel. Or F. Provide in the UPDF Act for the High Court to sit as a court martial with power to try all criminal capital offences within the High Court jurisdiction, and those unique to the military that attract the maximum life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeals sitting as such. Magistrates' Court would assume the jurisdiction over all other offences of a subordinate court. G. Make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where, in relation to specific class or category of persons and offences in question, ordinary courts are not in position to undertake such trial. H. Make provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in the ordinary courts. In each of the options suggested above, the jurisdiction of UBCS and SDS must be limited to that of tribunals, handling strictly disciplinary offences with no power of detention or imprisonment, as is the case with other disciplined forces, such as the police and prisons.